So, good day everyone. I'm Rosarin M. Laudet, the assigned reporter under the section 44 to 52. So, in the previous lessons, we already have a overview about this section. So, I only just need to emphasize the important part for each section. So, let's start. So, the first section to be tackled is section 44 titled Ultra Vires Acts of a Corporation. Ultra vires in Latin word means beyond the power. So, this is the act that the corporation committed outside its scope, corporate powers. Not all ultra vires acts are illegal. Some ultra vires acts is voidable and it can be ratified. Title 5, Bylaws. Ano nga ba ang bylaws? Bylaws, ito yung internal government of a corporation. It defines the duties and responsibilities of a directors, the trustees, or shareholders and members. Section 45, the adoption of bylaws. Dati, sa lumang corporation code, ito ay under ng section 46. At ang pagpapasa po ng bylaws dati, kailangan within 1 month pagkatapos mo ma-receive yung issuance of Certificate of Incorporation na pinasa mo sa SEC. Sa bagong corporation code, wala nang nakasaad kung hanggang kailan ba talaga pwede magpasa ng bylaws. Pero ang bylaws, pwede mong isabay sa pagpasa ng Article of Incorporation or after naman na ma-receive mo yung certification galing sa SEC. The bylaws shall be signed by a stockholders or member voting for them, and shall be kept in the principal office of a corporation, subject to the inspection of a stockholders or members during office hours. And of course, a copy thereof duly certified by a majority of the directors or trustees and countersigned by a secretary of a corporation, and it shall be filed with the commission and attached to a original articles of a incorporation. So, alam naman nating lahat na ang bylaws is magiging effective lamang pagkatapos mo matanggap yung certificate galing sa SEC at pinapatunayan na ang bylaws mo ay accordance with the law. Sa pangatlong bullet, applicable lamang to sa mga special corporation na kailangan ng pahintulot ng mga ibang institution bago aprobahan ang bylaws or i-amend ang bylaws, at kailangan syempre ito ay accordance with the law. Section 46, Contents of Bylaws. Ang nilalaman ng bylaws, syempre kailangan nakasaad dyan yung time, place, and manner of calling and conducting, kung ito man ay regular or special meetings ng directors or trustees. Syempre, nakasaad din dyan yung quorum ng meeting ng stockholders, members, and yung manner of voting. And the modes by which a stockholders, member, director, or trustees may attend meetings and cast their votes, and the form for proxies, if meron, of a stockholders and members, and the manner of voting them. Of course, nandyan din yung qualifications, duties, and responsibilities, the guidelines for setting the compensation of directors or trustees and officers, and the maximum number of other board representations that an independent director or trustees may have, which shall in no case be more than the number prescribed by a commission. And the time holding for the annual election of directors or trustees, and the mode and the manner of giving notice. And syempre, nandyan din yung manners of election or appointment and the term of office of all officers other than directors or trustees. Nakasaad din dyan yung penalties, violation sa bylaws. And in case of stock corporation, the manner of issuing stock certificates. Such other matters as may be necessary for the proper or convenient transaction of its corporate affairs for the promotion of good governance and anti-graft and corruption measures. An arbitration agreement may be provided, of course, in the bylaws pursuant to Section 181 to this code. In Section 47, Amendments to Bylaws. In amendments in bylaws, a majority of the board of directors or trustees and the owners of at least a majority of a outstanding capital stock and majority of members if it is a non-stock corporation. At a regular or special meeting duly called for the purpose of amendment or repeal the bylaws or adopt new bylaws. After that, syempre ipapasa ulit yan sa SEC. And kailangan may pirma yan ng corporate secretary and majority of director or trustees. Magiging effective lamang ang bylaw syempre kapag may issuance ng certificate galing sa SEC at kailangan ito ay accordance with the law. Title 6, Meetings. Section 48, Kinds of Meeting. There are meetings of directors, trustees, stockholders, or member. It may be regular or special. Section 49, Regular and Special Meetings of Stockholders or Members. So, the regular meeting, it is annually on a date fixed by the bylaws. If pag wala naman, any date after April 15 as determined by the board. Sa special meeting naman, anytime deemed necessary or it is provided in the bylaws. Saan ba ginaganap ang regular meeting? Siyempre, sa principal's office of the corporation, if it is not practicable in the city or municipality where the principal office of the corporation is located. Ang special meetings naman, ginaganap din sa principal's office of the corporation if it is not practicable sa city or municipality kung saan nandoon ang principal's office of a corporation. At sa pagbibigay naman ng notice in regular meetings within the period provided in the bylaws, if there is no such provision at least 21 days prior to the meeting. In special naman, pag nagbibigay ng notice, within the period fixed in the bylaws, if kapag wala naman, at least 1 week prior to the meeting. Sino ba yung mga presiding officer sa regular meeting? Siyempre, nandyan yung person designated na nakalagay sa bylaws. If na naman, chairman, or in his absence, the president. And sa special meeting, same lang din. At syempre, bago mag-start yung meeting, may pine-present muna na sa mga stockholders o member. Isa na dyan yung mga minutes of the most recent regular meetings, which shall include a description of the voting and vote tabulation procedures used in the previous meeting, and a description of the opportunity given to stockholders or members to ask a question, and a record of the questions asked and answer given, and the matter discussed and the resolution reached, a record of the voting results for each agenda item, a list of directors or trustees, officers, and stockholders or member who attended the meeting, and such other items that the Commission may require in the interest of good corporate governance and the protection of minority stockholders. And a member list for non-stock corporation and for stock corporations material information on the current stockholders and their voting rights, and a detailed, descriptive, balanced, and comprehensible assessment of the corporation's performance, which shall include information on any material change in the corporation's business, strategy, and other affairs. A financial report for the preceding year, which shall include financial statements duly signed and certified in accordance with this code and the rules that the Commission may prescribe. A statement on the adequacy of the corporation's internal controls of risk management systems, and a statement of all external audit and non-audit fees. An explanation of the dividend policy and the fact of payment of dividends or the reasons for non-payment thereof. Director or trustees profile, which shall include, among others, their qualification and relevant experience, length of service in the corporations, trainings, and continuing education attended, and their board representation in other corporation. A director or trustees attendance report indicating the attendance of each director or trustees at each of the meetings of the board and its committees and in regular special stockholders meetings. The appraisals and performance reports for the board and the criteria and procedure for assessment. A director or trustees compensation report prepared in accordance with this code and the rules and the Commission may prescribe. Director disclosures on self-dealings and related party transactions, and or the profiles of directors nominated or seeking election or re-election. And the director or trustees, stockholder or member may propose any other matter for inclusion in the agenda at any regular meetings of stockholders or members. Sobrang haba, no, bago mag-start yung meeting. Special meetings of stockholders or members shall be held at any time deemed necessary, as I mentioned earlier, or as provided in the bylaws. However, that at least 1 week written notice shall be sent to all stockholders or members unless a different period is provided in the bylaws, law, or regulation. The notice of any meeting may be waived expressly or impliedly by any stockholder or member, provided that the general waivers of notice in the Article of Incorporation or the bylaw shall not be allowed. Further, that the attendance at a meeting shall constitute a waiver of notice of such meeting, except when the person attends a meeting for the express purpose of objecting to the transaction of any business because the meeting is not lawfully called or convened. Whenever for any cause there is no person authorized or the person authorized unjustly refuses to call a meeting, the Commission, upon petition of a stockholder or member on a showing of a good cause, therefore, may issue an order directing that the petitioning stockholders or member to call a meeting of the corporation by giving proper notice required by this code or the bylaws. The petitioning stockholder or member shall preside thereat until at least a majority of the stockholders or members present have chosen from among themselves a presiding officer. At kapag ipopostpone naman yung meeting, kailangan 2 weeks prior may bigay na yung notice unless a different period is required under the bylaws, law, or regulation. And the right to vote of stockholders or member may be exercised in person through a proxy or when so authorized in the bylaws through remote communication or in absentia. The Commission shall issue the rules and regulation governing participation and voting through remote communication or in absentia, taking into account the company's scale, number of stockholders or members, structures, and other factors consistent with the protection and promotion of shareholders or meetings or members' meeting. In Section 50, place and time of meetings of stockholders or member, I already mentioned it earlier. So, the notice of meeting shall be in writing, and the time and the place thereof stated therein. And each notice of meeting shall further be accompanied by the following: the agenda for the meeting, a proxy form which shall be submitted to the corporate secretary within a reasonable time prior to the meeting. And when attendance, participation, and voting are allowed by remote communication or in absentia, the requirement and procedures to be followed when a stockholder or member elects either option. And when the meeting is for the election of directors or trustees, the requirements and procedure for nomination and election. And note that all proceedings and any business transacted at a meeting of the stockholders or member, if within the power or authority of the corporation, shall be valid even the meetings is improperly held or called. In Section 51, quorum in meetings. Unless otherwise provided for in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority outstanding capital stock or majority of the members in the case of non-stock corporation. If hindi naman naabot yung standard quorum, pwedeng may possibility na yung meeting is ma-cancelled or ma-postpone. Lastly, the Section 52, regular and special meetings of directors or trustees quorum. Unless the Articles of Incorporation or the bylaws provides for a greater majority, a majority of the directors or trustees as stated in the Articles of Incorporation shall constitute a quorum to transact corporate business, and every decision reached by at least a majority of the directors or trustees constituting a quorum except for the election of officers, which shall require the vote of a majority of all the members of the board, shall be valid as a corporate act. Kailan ba ginaganap ang regular meeting ng Board of Directors and Trustees? It is on the date fixed in the bylaws. If kapag wala naman, monthly. If in the special naman, at any time upon the call of a president or as provided in the bylaws. Saan ba ginaganap ang regular meeting? It is as fixed in the bylaws if pag wala namang provision na nakalagay sa bylaws, anywhere in or outside of the Philippines. Pag special naman, it is the same. If magsasend naman ng notice in regular, within the period but not be at least 2 days prior to the meeting provided in the bylaws. And in the absence of a provision in the bylaws, at least 2 days prior to the scheduled meeting. In special meeting naman, within the period but not at least 2 days prior to the meeting provided in the bylaws, and in the absence of a provision in the bylaws, at least 2 days prior to the scheduled meeting. And in the presiding officer, it is a person designated in the bylaws. If none, the chairman, or in his absence, the president. It is the same in the special meeting. At ang directors or trustees naman na hindi makaka-attend sa meeting ay pwedeng mag-participate through remote communication such as video conferencing, teleconferencing, or any alternative modes of communication. Hindi sila pwedeng mag-proxy kasi sila mismo yung gumagawa ng decision. And a director or trustee who has a potential interest in any related party transaction must recuse from voting on the approval of the related party transaction without prejudice to compliance with the requirements.